Can a person who invested in a housing project for profit, not possession, be called a home buyer under law? That's a million rupee question India's Supreme Court answered in a recent landmark judgment of Mansi Brar Fernandes versus Shubha Sharma, 2025. The year is 2025, it's a recent judgment. And trust me, this decision could change how real estate dispute under the Insolvency and Bankruptcy Code (IBC) are handled forever. The core dispute in Mansi Brar Fernandes versus Shubha Sharma centered on whether individuals who invest in real estate projects under the buyback or assured return scheme can be treated as a genuine home buyers entitled to initiate the insolvency proceeding under Section 7 of the Insolvency and Bankruptcy Code, that is IBC 2016. When the appellant claimed to be financial creditors seeking justice for delayed possession and non-payment, the respondent argued that such transactions were purely speculative investment aimed at earning high return rather than acquiring a home. The controversy raises a vital legal questions. Should the IBC mean for reviving distressed companies be used by investors seeking profit or refund? The Supreme Court had to draw a clear line between genuine home buyers and the speculative investors, ensuring that IBC remains a tool for revival and not a misuse. Mansi Brar signed an MOU with a builder in Greater Noida for 4 flats. It's a 4 flat, not 1, 2, 3. It's a 4 flat. So this is a clear investment. She paid 35 lakhs upfront. The agreement said either the builder will give her flat or buy them back for 1 crore after 12 months. The builder didn't deliver the flat or the money, and the checks bounced. So the Mansi filed an insolvency case claiming to be a financial creditor. The NCLT accepted his claim, but the appellate tribunal, the NCLAT, reversed, saying, "The wait, this looks like an investment and not a genuine home buying deal." So the Supreme Court asked, can someone with a buyback or assured return clause use the IBC as a recovery tool? The court answer was no. If you entered a profit, not a possession. If you entered for a profit, not for possession, you are a speculative investor and not a home buyer. This is a huge because it draws a clear line between real buyers who want homes and the investors who want return. The court said the IBC is for reviving projects, not for individual investor to recover money. It listed red flag that shows speculation, buyback or assured return clauses, unrealistic interest like 25% per annum, multiple flat bookings, no follow for possession, filing NI Act cases instead of taking flats. In Mansi's case, she invested 35 lakhs for 1 crore in a year. That's almost 300% return. The court said no genuine buyer expect that. Similarly, in other case, a buyer got 25% assured return. Again, a speculative. But here is the important part. The court didn't stop at rejecting a speculation. It reaffirmed that genuine buyers are protected under Article 21, the right to live and shelter. It said housing is not a commodity to gamble on. It's a fundamental human need. And those who invested their life saving deserve timely possession, not endless litigation. To fix the system, the court gave 12 base directions from the filing NCLT vacancies, strengthening RERA, ensuring project-wise insolvency, to creating a revival fund for stuck projects. So what the takeaway from this judgment? If you invested to live, you are protected. If you have invested to profit, IBC is not your tool. This judgment is a turning point. It separates real home buyers from the speculators and ensures that insolvency code focus on revival and not the recovery. As the court beautifully said, the IBC is not about ruin. It's about revival, not for profit seekers, but for the genuine home buyers who just want a home. This is the kind of clarity India's real estate market sector has needed for years. Thanks for turning into the Property Decoder. Myself, Anil Diwan.